I'm Judge Valerie Zachary. To my right is Judge John Airwood. To my left is Judge Fred Gore. We'll go on to our second case today, which is Southeastern Public Safety Group versus North Carolina Department of Justice et al. Counsel, are you ready to proceed? Have you reserved rebuttal time?
Yes, Your Honor. I would like to request 5 minutes for rebuttal, to reserve 5 minutes for rebuttal.
Okay.
Good afternoon, and may it please the court. My name is Trey Ellis, and I am an attorney with the North Carolina Department of Justice. I represent the defendants in this appeal, and I'd like to thank the court for the opportunity to present argument this afternoon. Your Honors, this is a case about Southeastern Public Safety Group's performance of services related to a highway construction project. To improve traffic flow along Interstate 77, the North Carolina Department of Transportation sought to undertake a project to build variable rate express toll lanes on the segment of I-77 that runs between Charlotte, North Carolina, and Statesville, North Carolina. In 2014...
And this is an interstate governed by the federal rules, is that correct?
The project, Your Honor, is a federally funded project. The project to add the toll lanes to Interstate 77 is a federally funded project, yes.
And Interstate 77 is a federal highway, is it not? Because it's part of the federal interstate system.
Yes, Your Honor, it is.
Are projects on I-77 subject to the North Carolina statutes?
Projects on I-77 are subject to the federal law, as Judge Arrowwood mentioned, but is subject to the yes, Your Honor. They are also subject to the North Carolina general statutes.
So, counsel, as the funding piece, has there been any other contracts outside of the agreements for funding for the federal government to expand anything beyond I-77 as far as the discussions for easements and real property and all those things? Or is there anything that I'm not seeing here that I've looked, but as far as the discussion is that it's federal project for funding, but with that funding, does that come with any property gains or anything outside of the funding, outside of the terminology that's used? I'm just making sure I'm understanding there.
Yes, Your Honor. No, Your Honor. The sole governing agreement for this project is the comprehensive agreement that was entered into by both the North Carolina Department of Transportation and the private company I-77 Mobility Partners to finance, design, and build the toll lanes. And mobility subcontractors are also subject to this comprehensive agreement. And in the comprehensive agreement, as we acknowledge on page 6 of our opening brief, the Department of Transportation granted mobility and its subcontractors a limited concession to enter onto the I-77 right-of-way owned by or subject to the control of the North Carolina Department of Transportation, necessary for the purposes of carrying out the work to construct, maintain, and toll the express lanes. As further noted on page 6 of our opening brief, the comprehensive agreement also made mobility and its subcontractors responsible for the general management of traffic on the applicable portion of the project under mobility's control. So that was the comprehensive agreement. Mobility then contracted with the company Sugar Creek Construction to actually build the lanes. And in 2016, Sugar Creek Construction then contracted with Southeastern, a company police agency, to provide law enforcement services and manage traffic within the section that covered Sugar Creek's active work zones on the project. And this is where the North Carolina Company Police Act comes into play. The Company Police Act allows people to hire certified private police forces, also known as company police, to provide law enforcement services. But company police only have limited jurisdiction. The Act states, as the court can find on page 4 of the appendix to our opening brief, Company police officers solely have jurisdiction on real property owned by or in the possession and control of their company police agency or the entity that has hired their agency. In 2017, the company police administrator responsible for administering and ensuring adherence to the act became aware that Southeastern was violating the law. Specifically, a Southeastern car had been seen driving down the interstate in the wrong direction in pursuit of a vehicle that was traveling southbound in a northbound lane, and had been seen using blue lights to impede traffic as Sugar Creek's construction crew placed barrels along active portions of the highway.
So, counsel, let me ask you that question. With some of those things coming to, I guess, Mr. Munn's attention, or however it was communicated, in reading both briefs, the appellee's brief seems to contend that the state or Mr. Munn's ability to challenge the contract is somehow an issue. Is it feasible, or has there been a practice to where if there are things that violate the act that might not be even in the contract or contract violation, is it Mr. Munn's purview to evaluate reports of those things that might not even come up within the contract that might violate the act itself?
Correct, Your Honor. It is the responsibility of Mr. Munn to investigate reports of potential violations of the Act, and to make a determination as to whether or not the Company Police Act has been violated. And so, Your Honor, when Mr. Munn then became aware of the situations of the Southeastern car driving the wrong direction down the interstate, as well as using blue lights to impede traffic.
Excuse me 1 minute. It doesn't look like this time clock is working.
I apologize.
Okay. How many minutes do we think we've, because we don't want to be unfair to the other party. How long do you think we've?
I would say 5 minutes if we started at.
Does that sound okay?
Yeah, that's about right.
Okay. Sorry to interrupt you.
No problem, Your Honor. So upon finding out about these occurrences, the company police administrator concluded that Sugar Creek did not have possession and control of the portion of the interstate where the Southeastern car engaged in these activities. To be clear, though, this isn't an enforcement action. There are no civil penalties or anything like that. The North Carolina Department of Justice just concluded that Southeastern couldn't operate in violation of the Act, and Southeastern sued us for that conclusion and decision. But here, as a result of the acts in the portion of the highway where there is free-flowing traffic, Southeastern acted outside of its jurisdiction in violation of the Company Police Act. And two reasons support that Southeastern did not have jurisdiction and therefore violated the Act. First, the contract between the North Carolina Department of Transportation and Mobility did not give Southeastern the jurisdiction that is required under the Act to police the free-flowing traffic portion of a public highway. Second, federal regulations have no bearing on whether Southeastern has jurisdiction under state law to police the free-flowing traffic portion of a public highway. And because Southeastern did not have the necessary jurisdiction in the free-flowing traffic portion of the highway, we ask that this court reverse the erroneous decision of the Superior Court.
Counsel, let me stop you. I guess let's take the free-flowing part out. Say if there were, I know some people call them HESCO barriers, but if we're here addressing whether there were arrests made for people driving in between the concrete barriers or driving on the closed area, which there's a separate, North Carolina law for that. For the closed off areas, do we have an issue whenever we're talking about the closed off areas in between the concrete barriers or the 10-mile stretch of the road that's not open yet? Do we have an issue there?
No, Your Honor, we do not have issue with that. and that is reflected in the language of the contract, specifically.
Okay, let's stop right there then. If we don't have an issue there, a person's charged with a Chapter 20 violation, because when I go back and look at the Act, there's clear provisions within the Act that address felonies and misdemeanors.
Yes.
Where does the Act allow for, and I know I don't think it's really that clear, but if Southeastern does not have anybody that's trained on Chapter 20 law, do we have an issue of them enforcing specific Chapter 20 if nobody's radar certified and they're charged with a radar speed or something like that? Do we have issues with the scope there as well?
Well, the only that's not a question that's before the court in this case. In response to that, I think I would just say that company police agencies have the power to same powers as municipal and county police officers to make arrests for felonies and misdemeanors and to charge for infractions.
Okay.
And so to the extent that that would apply in that situation, that is how the Company Police Act would be pertinent in that hypothetical.
Fair enough. Thank you.
Why doesn't a limited concession constitute a temporary possessory interest?
Well, Your Honor, a limited concession, first is the term concession is not defined in the general statute or in the contract. So we've referenced the Black Law Dictionary definition of
Is
concession.
it defined in
thought-
federal regulations?
Your Honor, concession is not defined in the federal regulations, no.
Did the contract not provide that a concession is intangible personal property and not an interest in real estate?
Well, Your Honor, and if I might refer to the provision that Your Honor is referring to, I believe Your Honor is referring to Section 2.1.4 of the Comprehensive Agreement, in which, and with that, the term concession doesn't seem to be present in that. Well, it is. Excuse me. The term. That specific subsection is found within the section of the grant of concession. But within that subsection is also the subsection 2.1.2, which grants to mobility a concession to enter onto the right-of-way for owned by or subject to the control of the North Carolina Department of Transportation, necessary for the purposes of carrying out the work of the project. And the work of the project is to construct and to build the lanes. And so therefore, should there have that limited concession would indicate that it would apply solely to the area where the building and the construction would be taking place, and therefore that is the only area where Southeastern would have had jurisdiction.
So are you differentiating between the project area and a work area?
Your Honor, according to the comprehensive agreement, the project area is the general I-77 segment of I-77.
Just a segment, not all. I mean,
Correct. The segment.
26 miles, right?
Correct. Yes, the full 26 miles. However, there were portions that were one portion which was being constructed upon, and one portion which was not, which was the free-flowing traffic portion of I-77.
But
And so,
not all of the established lanes were free-flowing, were they?
well, Your Honor, again, I would.
And before you answer that, you should know I live in Charlotte and drive that.
Yes, sir. Well, being from Charlotte, I love hearing that. But so to answer your question, Your Honor, I would just reiterate the distinction between the free-flowing portions of Interstate 77 and the portions on which the construction and building was taking place. And with, again, in referencing that provision in Section 2.1.2 of the Comprehensive Agreement that grants the limited concession to enter onto the I-77 right-of-way that was owned by or subject to the control of the State Department of Transportation, only necessary for the purposes of carrying out the work of the project. And so, again, that is exclusive to areas where the work was taking place and not to areas where there was free-flowing traffic, where vehicles were traveling back and forth.
Doesn't the contract provide, though, that you need to control traffic before you reach a work zone? In order, for safety reasons or, for whatever? I mean, can we really limit it just to where they're working on the Hot Lanes project?
Yes, Your Honor. With the contract specifically provides in Section 9.2.1 of the Comprehensive Agreement that Mobility was responsible for the general management of traffic on the applicable portion of the project under the control of Mobility. And so that applicable portion would be the portion on which construction and building was taking place, and not the portion of the highway where there was free-flowing traffic and cars traveling back and forth.
So are you saying that the traffic had to be free-flowing right until you got to where they're actually working on the road? They couldn't control traffic anywhere before that to slow traffic down, to make things a little safer? They couldn't do any of that?
Well, Your Honor, pursuant to the agreement, the scope of control and the scope of jurisdiction of Southeastern was the portion where the work was occurring. And with that, Your Honor, there's also a provision that explicitly excludes the transfer of a possessory interest subject to that limited concession. That specific language is in Section 2.1.3 of the Comprehensive Agreement, and that states that, again, subject to the section of the agreement that grants the limiting concession, Mobility does not have any fee title, leasehold estate, possessory interest, permit, easement, or other real property interest of any kind in this right-of-way. And so, with that specific language, Southeastern violated the act with the performance of services in the free-flowing traffic portion of I-77.
Counsel, how does that intention of the department rationalize with the finding of the trial judge in that somehow there was interest conveyed because of the federal regulations?
Well, Your Honor, I actually would like to turn to the federal regulations next. And these are federal regulations that both Southeastern and the Superior Court relied on.
And these federal regulations that we're returning to, are these the federal regulations that the administrative law judge refused to consider, refused to introduce, refused to let them be introduced, and refused to consider them?
Yes, Your Honor.
And if they're a part of this, this is where I want you to, this is my question. If it's a part of this, and it's a part of the contract, then how is it not an abuse of, whether if she considered them and said, no, I don't think they apply, but as I read it, she refused to consider it or let it be introduced. How is that not an abuse of discretion on her part?
Well, Your Honor, first, the state's contention is that federal regulations have no bearing in this case and in this contract. That is to
say
be
that when it talks about that because there's federal funding,
yes,
and it says that those federal regulations apply
yes,
where there's federal funding. How can the state take that position?
Yes, Your Honor. I misspoke. The federal regulations that plaintiff cites and that the Superior Court relies on do not apply to this contract. Specifically, plaintiff and the Superior Court state that the Comprehensive Agreement incorporates the definitions of right-of-way and work zone as they are defined in the Code of Federal Regulations. However, as can be found in footnote 4 on page 11 of our reply brief, the contract only states that mobility and its contractors shall comply with all federal requirements applicable, and that where there is any conflict between the requirements of the comprehensive agreement and federal requirements, the federal requirements shall prevail. And that is in section 23.1 of the comprehensive agreement as well.
Well,
So-
my question is, how can the ALJ determine whether that, when she refused to let it be introduced or refused to consider it, that's my question is, how can she do that? How can you do that if she won't even look at it?
Well, Your Honor, I think that was a question appropriate for the Superior Court. More of the
The
question.
Superior Court answered it. I'm asking you why the Superior Court was wrong in finding that she abused her discretion in failing to consider it.
Well, Your Honor,
I have another question for them about whether what the Superior Court did was correct, but my question to you is, why is the Superior Court wrong in saying it's abuse of discretion for her to fail to even let it be admitted or to consider whether it applied?
Well, I think the decision to not consider their applicability is because they are inapplicable and they have no bearing.
But she didn't admit it to even consider that, as I understand it. Isn't that correct?
Yes, Your Honor. Yes, Your Honor. But I would reiterate the lack of applicability of these specific federal regulations, and specifically one of the regulations that are relied upon is the definition of work zone. And again, the comprehensive agreement solely requires that the mobility and its contractors comply with federal requirements that are applicable.
What's the difference between a requirement and a regulation?
Well, there are, within the regulations, there are definitions as well as requirements. There are definitions that do not impose any kind of requirements, and there are there are regulations that include definitions that do not impose any kinds of requirements, and there are regulations that explicitly impose requirements.
But did the ALJ refuse to consider any of the regulations?
Yes, Your Honor, the ALJ did.
Even if the federal regulations apply, doesn't the company have to adhere to the provisions of the Company Police Act?
Correct. Yes, Your Honor. And that is the pertinent law that is in question here, or not in question, but that applies here. And again, under the Company Police Act, Southeastern and other company police agencies like it only have jurisdiction on real property owned by or in the possession and control of their company police agency or the entity that has hired their agency. So,
And was that present here?
I'm sorry, Your Honor?
What you just said. You said that they have to have possessory or possessory control.
Correct.
Did they have that here?
The provision that grants the limited concession that allows the mobility to enter onto the right-of-way of I-77 in order to complete the work for the purposes necessary to complete the work of the project is the only extent to which.
Didn't you just read us a section of the contract that provided that there was no interest in real estate being conveyed?
Yes, Your Honor, but that's subject to the provision providing the limiting concession. And again, pursuant to Section 2.1.3 of the Comprehensive Agreement, subject to Section 2.1.2, which is the section that provides that limiting concession, the developer has no fee, title, leasehold, possessory interest, etc. And so it is subject to that provision. And so, Your Honors, I'd like to discuss just briefly a little more about why the federal regulations do not apply to the contract here. Again, the reliance on the definitions when the contract only calls for compliance with federal requirements that are applicable is not in place, and even even those terms, definitions in the Code of Regulations apply just to specific and limited parts of the code, which is something that the Superior Court did not recognize. So, for instance, with work zone, the term work zone, as cited by the Superior Court, applies only to a subpart of the code, which addresses work zone safety and mobility. And the Superior Court did not cite any sections of the code that actually use the term work zone to impose any substantive requirements or rules that bind the North Carolina Department of Transportation or its contractors. And second, there is another federal regulation that's cited by plaintiff and relied on by the Superior Court that actually does have a substantive rule requirement. The regulation is 23 CFR section 710.305B, and the court can find this on page 9 of the appendix to our opening brief. And this regulation provides that the real property interests acquired by any federally funded project must be adequate to fulfill the purpose of the project. And in its order, the Superior Court interpreted this regulation incorrectly. It stated that this federal regulation required that the real property interest acquired by the contractor from the State Department of Transportation or other entity must be adequate to fulfill the purpose of the project.
Can't it be adequate to fulfill the purpose of the contract? And perhaps Southeastern just wasn't able to fulfill it because they couldn't fulfill it and also comply with the Company Police Act.
Correct, Your Honor. And in fact, that's exactly what happened. Even if we consider we consider the hypothetical of Mobility and Sugar Creek Construction being grantees of the federal funding, the project and the purpose of the project was adequately fulfilled. The project itself, the Express Lanes project, was finished in December of 2020, almost 4 years ago. And so with that, Your Honors, these regulations don't demand the use of private law enforcement agencies, and they fail to require that Southeastern be allowed to manage traffic.
So, counsel, so if we're looking at the follow-up question to what Judge Zachary asked, is it adequate and then they hire Southeastern and Southeastern just stays within the boundary lines of where the work's being done and doesn't come out in the free-flowing lanes? And I think your interpretation, just to follow up with Judge Arwood's question or Judge Zachary's question, free-flowing, you mean where the lanes are just going and there's no stopping it regardless of whether it's in the work zone or not. If Southeastern stays inside the cones and enforces, no issue with the Police Act. If they come outside the cones and gets on the highway and starts doing DWI checkpoints and stuff, violation of the Police Act. Is that fair enough to?
Yes, that is fair, and that is correct, Your Honor.
So with that said, is that why, and to not to jump on the brief of the counterpart, yet where there's contention about, it seems like just deputy sheriffs or other municipalities are hired, is that within the scope that then they can then follow on and chase those folks or go after those folks down the road past the work zone areas?
Well, Your Honor, again, this comes back to what the Company Police Act provides, and that is for Southeastern to exercise jurisdiction only where the property was in the possession or control of the entity that had hired them. And in this instance, Sugar Creek was that entity. And the comprehensive agreement provides exactly where that jurisdiction applied. Your Honors, I see that I've cut into my rebuttal time.
Well, we can give you a little extra since we've been asking you all these questions. But couldn't they hire the company, hire Southeastern to do the work in the work zones and then hire off-duty police officers to manage the other part, that Southeastern was not entitled to manage?
Yes, Your Honor. Yes, they could. And in fact, of course, not happening at the same time, but that's essentially what happened in Southeastern providing the services within the work zone. If they had not gone outside of that zone, it could have been possible for the off-duty, for police officers, county and municipal police officers, to provide those services at the same time. And in fact, this case is the first instance in the history of the state of North Carolina in which a company police agency has been hired for these services. Traditionally, it has been county and municipal police officers, and so that would be very much possible.
Okay. Do you have any further? Okay, no further questions.
All right, thank you.
We'll give you a little extra time since we peppered you with questions.
Thank you so much, Your Honor.
May it please the court, honorable judges of the Court of Appeals, I appreciate the opportunity to argue on behalf of my client. I've been involved in this case, I think, for going on 5 years at this point. I do want to start off by saying I think it's important to note company police officers and agencies are not the only law enforcement agencies in this state or any state that have limited jurisdiction. They're all limited. There's limits on the jurisdiction of county police officers based on county. There's limits on the jurisdiction of city police officers based on city limits. It's no different. It's all based on property lines. The difference is that company police agencies' jurisdictional property lines are either determined based on their employer's property lines. If it's a company police officer directly employed by an employer, most common example would be like campus police officer, campus police agency on campus, the light rail, for those of you who are familiar with Charlotte, that type of police agency, which their property jurisdictions are based on the light rail. Apartment complex, sometimes different hospitals, I believe, may sometimes have law enforcement officers too, but it's still, all jurisdiction is based on property.
And counsel, in those scenarios, isn't there 9 times out of 10 because of the continuing relationship of those entities, whether it's the apartment complex, the school, the hospital, isn't there most of the time a memorandum of agreement of how far beyond the driveway or the property line? Aren't there memorandums of agreement with some of those agencies and the local municipality or the county?
Of course.
Okay.
I mean, there's still, I don't think there would be an agreement that would allow them to go off of those lines no matter what, unless they were in active pursuit.
Well,
True.
isn't it a different section of the statute?
Yes.
Yeah.
Yes. The general argument has been, and the issue in this case from the gate has been whether or not Southeastern was operating on real property owned by and or in the possession or control of the entity with which it had contracted, in this case being Sugar Creek Construction. And it's somewhat convoluted because there are multiple contracts in this case. The prime contract between the NCDOT and Mobility Partners is a publicly accessible contract. I believe it's argued in one of the briefs that it wasn't omitted by the ALJ on hearsay purposes, but again, it's an exception. It is a public document. It is a voluminous public document, hence probably part of some of her hesitation in declining to review it. But one of the things that I think is clear and important in that document is a couple of things. It uses the same terminology from the federal regulation. So as far as defining real property interests and that sort of thing, it talks consistently in terms of right-of-way. It talks about a right-of-way. When, I believe it was Whitney Belich, the Assistant Attorney General advising the administrative law judge at the time, made her opinion on whether or not Southeastern was able to work on it, meaning whether or not either Sugar Creek or the Department of Transportation had possession of control. She specifically based her opinion on her understanding of what right-of-way meant. And in some of the record and some of the documents that were provided to us after the first remand from the Superior Court back to the ALJ, there was further communication where she had said she'd tried to get further clarification on some of the terminology from the Department of Transportation, the State Department of Transportation, and had been unsuccessful. I think part of the confusion from our perspective as to the basis of the administrative law judge, the company police administrator's opinion about Southeastern's ability to do what it was doing is that it has changed. And I know I argued that in the brief. Initially, at the initial hearing, the company police administrator stated that roads can't be real property. And so that's why they were acting with outside of their jurisdiction, because they were on a road, can't be real property. Then that changed to, later, the Department of Transportation did not have possession and control over the travel lanes of I-77.
Didn't the contract provide explicitly that there was no conveyance of any interest in real property?
It says ambiguous and sometimes inconsistent things in that contract. What I do think is important to note, which my colleague brought to your attention, is that that contract specifically says any contradictions in the contract and the federal regulations, whatever they are, the federal regulations prevail.
But if the federal regulations say that you need to, or you must, convey that interest, and they don't, and then they hire someone or a company like Southeastern to provide these services, which it cannot do legally under the Company Police Act, how does that give Southeastern the interest in real estate that it needs in order to be able to operate legally under the Company Police Act?
So Sugar Creek would have that interest in the real property for my client, Southeastern, to be able to.
Okay.
to
Well, how does it give it to Sugar Creek?
Well, it says it does in other parts of the contract because it talks about a right-of-way, and the right-of-way is defined as a real property interest. It is a concession because it varies. So like the actual area they're working on, because it's rolling roadblocks. So the area of the highway that they're working on changes during the night, changes from one day to the next because those roadblocks are rolling. So as far as it being a property interest, it is a property interest. It's not one that would be recognized under property law because it's not conveyable. It is temporary. And it does talk about that at other points in the contract. Specifically, and I did argue in the brief, that the Department of Transportation made sure to include in that contract language, and if you'll bear with me for 1 second,
I guess, counsel, as you look, go ahead and look that up. I got a question for you once.
Yes, Your Honor. And it specifically states that one of the requirements at the end of the project is that possession and control be returned to the Department of Transportation. And so certainly they have conveyed at least a temporary possession. And I do need to step back for a second and explain. In the Company Police Act, it talks about ownership and possession and control. And you can have possession and control over something without necessarily having what we would consider a real property interest that's conveyable, which goes more to the ownership part. And neither of those are defined in the statute. Neither of those are defined in the regulations. Neither of those have been interpreted by any of our courts. But it is clear that at least for the duration of the project, which I believe was actually a 26-year project, so it's something that's actually still ongoing, even though the toll lanes have been completed because they're actually being managed now. But in that contract, it states that the developer, which is Mobility Partners, which includes Sugar Creek, shall relinquish and surrender full control and possession of the project and the project right-of-way to the Department of Transportation at the completion of the project. And again, the right-of-way is the area that was being worked on, which the work zone, as defined, and there's a very lengthy map in the contract that's called the project right-of-way, or I think it's like I-77 Project Mobility Partners right-of-way or something like that, and includes the entire interstate, both going up and down from exit 3 to exit 26, I believe was what it was. And so part of the work zone included the free-flowing travel lanes because they changed. I mean, it was constant. It was a relatively constant change in project area.
I guess, counsel,
project needs.
so when we look at the property line or jurisdiction, was there any necessity for Southeastern to be enforcing Chapter 20 violations outside of the easement or the blocked off roads? Because if somebody's not pulling over into the coned area to block a bulldozer from moving, if nobody's pulling over blocking a dump truck from moving, what need was there for Southeastern to enforce Chapter 20 violations outside of that line of where construction was taking place?
Your Honor, if I'm understanding your question correct, it's kind of two-part, because there would have been a need for law enforcement agencies to do that because it's required by the federal regulations, it's required by the traffic management plan, which was developed.
Not denying that need. I'm asking for the need from when you come outside of the cones and traffic, and you're happy because we're flowing. We're down. We're getting out of Charlotte, as Judge Arrowood said, and we're heading up to Statesville, and we're flowing. no need, or what is the need for Southeastern to be enforcing Chapter 20 violations in those lanes that are flowing? Because I see a need for there to be an enforcement when you pull over and you're inside the cones and you're blocking a dump truck from rolling, that asphalt, can't back up. What is the need for Southeastern to go beyond, because I think the question is, where's the line? Well, I think there's a clear line inside the cones and outside the cones. What is the need for Southeastern to enforce Chapter 20 violations outside of the cone line and the free-flowing lane?
And I guess essentially the short answer is that the traffic management plan requires it. It requires, and the CFR specifically says that part of what has to be provided in the work zone.
But isn't that already provided by North Carolina State Highway Patrol? Is that already provided by, the county municipal law enforcement? Or if they go with, if whatever road's being worked on, if sends out a memorandum of agreement, because is Southeastern going to do a crash report?
Company police have done crash reports. Company
Okay.
police, there was one of the cases that's included, that was cited in the brief. There was a company police officer, I believe, who started a DWI investigation. So, they do that. They've done that.
Not denying the investigative part, but I'm saying, are they going to stay out there to do all of the Chapter 20? So what I'm getting at is, what is the need? Because the question is, where is the line? If they're hired to enforce the management piece of it inside of there to keep, felonies and misdemeanors, what need, if they're focusing on that, is there for them to, when there's other agencies that they can call in to enforce it in the free-flowing part, why are they outside of that line?
And again, the work zone as defined by the contract and by the Code of Federal Regulations is the entire interstate.
Okay.
And it's specifically in the
But
definition.
again, let's leave the code out of it, because we got to comply with what in North Carolina? The Police Act. So, and again, that's the question that we have here today, of where is that possessory interest? Is there a possessory interest outside the cones, or is it just to the inside of the cone?
Well, I would contend it's outside the cones too, because that's part of the work zone as well. Again, that whole part fluctuates. It's in flux during the whole project.
Are you maintaining that that's part of the work zone because that's what the federal regulations say?
Yes, and then the contract between the entities adopts the federal regulations definitions. That is our position.
Are you arguing then that the Company Police Act is basically irrelevant?
Not at all. We're just arguing that the property jurisdiction limits in this case were as defined in the right-of-way in the contract, which is from, I believe, it's exit 3A to exit 26 on the interstate. And that's part of the evidence that the administrative law judge wouldn't let in is the contract, because she says it wasn't relevant. Because at that time, it was the company police administrator's position that company police officers cannot ever enforce laws on roads. And there's nothing in the Company Police Act that says that. And when we're talking about contracts between private entities and company police officers, it's our position, and we didn't necessarily want to go down this road because I would contend it's outside of Judge Warren's order at this point. But as far as the ability for Sugar Creek to contract with municipal law enforcement officers, which my colleague, I believe, brought out that they in fact did to complete this project, again, is in violation of the federal regulations. This is a federally funded project. The federal regulations specify that for purposes of providing law enforcement services on those federally funded D.O.J projects, that the only money can be paid by whether it's a grantee or a sub-grantee. It can't be paid to a law enforcement officer. It can only be paid to a law enforcement agency. And so in this case, the only agencies that can contract with private entities in North Carolina under and in compliance with the Company Police Act are company police agencies.
Well, I have a question about, we're talking about federal regulations and a contract which the ALJ refused to admit, which then the Superior Court judge relied upon. My question for you is, if it were an abuse of discretion for the ALJ to refuse to even consider this, why isn't the proper remedy defined as rather than this very long order where the Superior Court judge then makes the decision themselves, why isn't the proper remedy, say, it's abuse of discretion, should have considered it, I'm sending it back for you to consider all of these questions that we're now asking here, as opposed, and make findings on those things? Why is that not the proper, as opposed to the Superior Court doing what the Superior Court did here?
Sure. Your Honor, I think that could have been a proper remedy. I don't think it's the only possible remedy, given the fact that it had already been sent back to the administrative law judge once before by Judge Hoover. He had made a specific finding that the company police administrator had withheld material evidence that needed to be considered, sent it back. And in
But he
the
didn't send it back for this reason.
He didn't, but in the ALJ's second decision, she specifically said that it wasn't, she made decisions that were contradictory to what the Superior Court's instructions were. So she said it wasn't material and it wasn't timely presented. And so Judge Warren had that information before him, and I'm speculating to say this, but it's possible that he believed remanding it would have been futile.
But isn't that but my question under the Administrative Procedures Act and under the appeal, isn't that the proper thing to do is to send it back?
No, not on all of the grounds. And so depending on, and I did argue this in the brief, and I don't want to necessarily just restate my prior arguments, but the judge can make findings himself. There's two different types of review that can be done when you're reviewing the decision of an administrative agency. Those two different types of review have different results that can come from them. There's the whole record test, and then also, and we didn't just argue like abuse of discretion. I mean, we argued, arbitrary, capricious, constitutional violations as well. And so for some of the other violations that weren't just, abuse of discretion, the judge is able to substitute his, the Superior Court judge is able under the law to substitute his opinion for the administrative law judge to consider the things that she didn't consider and to make a whole new order. And that's consistent with the law, although a remand would have also been consistent with the law too, but he can, under the law, under the second standard of review, he can substitute his opinion and render a new decision.
Counsel, you said earlier that the federal law prohibits the company from contracting with law enforcement individually, correct?
From paying.
From paying.
Yes.
And you said they have to contract with agencies.
They have to pay, yes. It's specific money.
So is it not capable for the company to contract with the sheriff's department directly and with a PD directly and not with individual officers individually?
So it is my reading from the Company Police Act that the only entity, and it's only entity, so it has to be a corporation or an entity.
I'm talking about your interpretation of the federal requirement that you stated earlier, that you have to contract with an agency. That was what my understanding of what you said.
Correct.
So is not the sheriff's department a police agency?
I think with the sheriff's department, it gets a little complicated because of the sheriff's constitutional status, but certainly.
Or a police PD.
Department,
yes,
sure.
that is an agency. So they could contract with them directly and not pay the individual. They could pay the agency and then it trickle down from there,
I
correct?
think that's correct. It's not what they do.
I understood, but what I'm saying, and again, regardless of what is done, I'm asking what is the law on it to make sure that there's an accurate reflection of what's stated here today. So if that's the case, why couldn't, what is the conflict with that being done? You said that's not what they do. So now follow on with that follow. You said that's not what they do.
So one of the cases that the Company Police Administrator included in their reply brief is the Lassiter versus Robeson County Sheriff's Office case, which is currently pending review now in front of the Supreme Court, where it's clear that there was a contract between the agencies, but payment was made directly to the officer. And so that's part of the, it's my position is that is unlawful. I mean, for a federally funded project, I don't believe that case goes into whether or not that project was federally funded. It was a DOT project.
So again, that's still back to the funding piece
Correct.
versus inside the cones, outside the cones.
Sure. So just again, to answer your question, I think also in the secondary employment agreement that they attached to their brief, that indicates the way they do it is the officer is paid directly. Again, for these types of projects. And again, going back to the Company Police Act, which it's been our position, we were in compliance with the whole time, We were never outside of the property jurisdiction limits of the project area, which included the free-flowing travel lanes. And also the contract is what defines the property jurisdiction, which is what defines the jurisdiction of the company police agency. And then the Company Police Act itself states that no one can provide police services to a private entity, to a not the public at large, unless they are first certified as a company police agency. And so getting back to the question earlier, I think that if municipalities and sheriff's departments under the law wish to provide private police services, that they also have to comply with the provisions of the Company Police Act as stated. It's the only act in the state that deals with providing law enforcement services to private entities, period. There's no other law that deals with that. I know that in the lower courts, the company police administrator has referred to the State v. Gaines case. I know both of us cited it in our briefs. There's another case, I think it was State v. Lassiter, that the company police administrator attached as well. And I think it's important to note that in both of those cases, the police officers who were working off duty were working off duty as security guards. And there's a huge difference between that with respect to company police agencies and officers. They go to this, they are all done through the Criminal Justice Trainings and Standards Division. They have the same training, they have the same, they go back to they have the same requirements.
And that being said, I guess my question is, if we have in this scenario, I don't know if we're in Iredale, depending upon the area that's being constructed, if we have Iredale Sheriff's Office out there doing that, and then there's some Chapter 20 or hit and run in the lanes of flowing, we don't have an issue at that point, because if that person continues on down the road past the work area, we don't have any jurisdictional question or issues with that enforcement of the Chapter 20 laws, do we?
No.
Okay.
But again, company police officers have the same jurisdictions for felonies, misdemeanors, and infractions. So there's no distinction between their, and a lot of times they go
But in the
back.
Police Act, they can't do that past where the property line of that possession is, correct?
There is an incontinuous pursuit, just like there is an incontinuous pursuit provision in the Company Police Act as well that says they can if they're in continuous pursuit.
But is there an agreement with Southeastern that, hey, you guys can pursue a mile down the road? Because most of the time, that continuous pursuit with the municipality or county goes a certain distance before somebody else has to take over, correct?
And you're
Because I didn't see in the Police Act where there was, hey, they can pursue 12 miles past where so where does the Police Act grant that continuous pursuit?
Well, it expressly provides the blue lights if they're in continuous pursuit. That is one of where it's talking about, I guess it's in the regulations where it's talking about prohibited acts.
Where's that in the Police Act, though?
I will defer to you. I understand. It's in the regulations. It's in the.
Again, North Carolina
Sure.
law. Where is it in the Police Act?
And when I say regulations, I am referring to the North Carolina regulations.
Understood, but that's separate and apart
Sure.
from what we're talking about from a jurisdictional enforcement piece, which is right now controlling is the Police Act, correct?
That is correct.
All right.
And just bear with me for 1 second, Your Honor.
Okay.
Because I actually do believe it's in there. Yes, it's 74E6C3. Any other real property while in continuous and immediate pursuit of a person for an offense committed upon property described in subdivisions 1 or 2.
So how far is that pursuit allowed?
And again, Your Honor,
Because again, most of the time, most municipalities and counties will have an understanding of how far you're going to come over into our jurisdiction, correct?
And Your Honor, company police agencies can enter into the mutual aid agreements with they do actually, with other law enforcement agencies to clarify it. I think that goes a little outside the scope of what the issues in this case were, so I haven't really gone into whether or not, I can tell, Your Honor, it wasn't expressly stated in the contract, but I'm sure there probably was some sort of discussion.
It would have helped us show where the line was, correct?
Well, but, Your Honor, again, our contention is the line where the contract says the line is, because it's got it drawn. Like, there is an actual diagram that says from, and I'm not just talking about in the regulations, but in the contract, there's a picture that says from this exit to this exit, all over the interstate, is the project area. And we're not talking about any type, and I think this is where the confusion and conflict may come in as far as the property interest, because this was not a property interest that was maintained all the time, because once they stopped working on it, they didn't have possession and control over it. And when I say that, I mean when they weren't working on it during the day, they didn't have possession and control or any interest of it. But when they were, and I know the police officers had to have lights on while you're approaching. They had to make sure people know that there's a construction zone going. So there were all of those things that Southeastern did. I think it's important to note also that they provided this contract to the company police administrator when they started it. In fact, the record it shows that they actually communicated with the DOT prior to entering into the contract. As soon as they got the contract, they sent it to the company police administrator. No comments, no concerns, no questions. They worked the contract for 8 months. And then upon a complaint from a competitor, that's when this began. I also think it's important to note that before the lower courts, the company police administrator denied doing an investigation of what Southeastern was doing at the time because they didn't take any enforcement action. That was something that the administrative law judge found in her both decisions, was that there was no adverse action taken. I also think that's part of why Judge Warren issued the decision that he did, because she never reached in either decision whether or not Southeastern could otherwise be an aggrieved party because they were deprived of property. And they were deprived of property. They were deprived of the ability to work this contract. Sugar Creek was required to police the area, including the travel lanes of the work zone, not anywhere out and not when it was not being worked upon. But they were required by their contract with Mobility Partners to do that, to provide traffic management. They contracted with Southeastern to do that, and Southeastern was doing it without issue, again, until the complaint arose.
But wasn't their ability to provide traffic management limited by the Company Police Act?
Again, the Company Police Act, as many laws, could have been clearer worded, but it says any real property owned by or in the possession and control. And so it's Southeastern's position, it was Sugar Creek's position, it was for a long period of time the Department of Transportation's position that Sugar Creek had possession and control over that area.
Okay, I know you've explained it before, just explain it to me one more time. How did Sugar Creek have possession and control of those 26 miles?
The contract gave them the ability to do things to it, to direct traffic, to improve it, to prevent people from coming onto it, to get people off of it, to provide law enforcement services on it.
I thought that was the limited concession.
It's still proper. I mean, it's still either possession. However, to couch it, it's either a possessory interest or or control over that highway. I mean, they could stop somebody from coming onto it. Apparently, they could stop, or at least the DOT thought they could stop them from getting access to it again because they put in the contract that you have to give control back to us when you're done with the project. So certainly there was some understanding that they would have control over that area. I mean, again, just going back to the federal regulations, because I do think they're relevant. Again, this is a federally funded project, but the federal regulations, as the contract says, prevail over any inconsistent terminology in the contract. And the federal regulations require that the Department of Transportation itself have enough possession and control over it to convey it to whoever's doing the work on the project area. So somebody has to have possession and control. And again, as I've argued in the brief, not to rehash everything, but if they didn't have possession and control over it, they couldn't have done work on it, and they couldn't have contracted with law enforcement.
Couldn't they have done work on it improperly? Isn't it possible that DOT had possession and control and didn't convey it?
Theoretically, I do think that's probably possible, but I don't see, again, if they didn't convey possession to they're required, if they're giving their subgrantees, if they're giving them federal funds, then they're required to give enough possessory interest in the property that whoever that subgrantee is can complete the project.
But as we both know, just because you're required to do something doesn't mean you're going to do it.
I completely understand, but for all intents and purposes, and from the evidence that was before the Superior Court judge, that's what happened. Again, none of this stuff was allowed to be discussed. The company police administrator said he didn't even look at the prime contract before making his decision. He thought that roads aren't real property. Roads can't be, policed by anyone other than public law enforcement. without anything in the Company Police Act that says that, if the roads are within the property jurisdiction of the contract, which again has always been Southeastern's position, is that they were working within those property limits as set out by the contract.
Okay,
Okay, thank you.
thank you very much.
Just a few brief points, Your Honor. First, in response to Judge Arrowwood's questions earlier about whether or not it may have been an abuse of discretion on the part of the ALJ to not consider the regulations, the federal regulations. It may have been error for the ALJ not to consider the regulations, but it's harmless here. The meaning of...
She also didn't consider the contract, didn't she? She wouldn't admit the contract.
Well, Your Honor, the...
And if the contract is an integral part of this, how is that harmless error?
Well, Your Honor, agreed that the contract is an integral part of this, and with the ALJ's consideration or lack of consideration of the federal regulations, though, the meaning of the regulations is a question of law. And this court has the power to review that question of law on appeal. And so remand wouldn't be necessary because the issue of the applicability and the meaning of the federal regulations is an issue of law. With respect now to...
What about the contract?
Well, Your Honor, with the lack of consideration of the contract, it is true that the administrative law judge, it would be an integral part of the consideration of whether or not there is compliance with the Company Police Act. And yes, Your Honor, that would be something for the administrative law judge to consider.
And the federal regulations are incorporated by reference to a certain extent within the contract, am I correct?
Well, only federal, the contract requires that the parties comply with federal requirements. So not all of the federal regulations only the federal regulations that would impose a requirement on either of the parties. And a second point I wanted to raise in regard to what my colleague on the other side argued. Throughout the entirety of their argument, they didn't identify anything during their argument that gave Sugar Creek the possession and control of the free-flowing portion of I-77 that is required to be in compliance with the Company Police Act.
Okay, you've gone into your time.
My apologies, Your Honor. In conclusion, the state would respectfully request that this court reverse the Superior Court's erroneous decision and conclude that that Southeastern did not have jurisdiction in this case.
Okay, thank you. That concludes oral argument in this matter, and we'll take this under advisement. I want to thank you both for your excellent arguments. This is a thorny case. We'd like to go into ceremonial session now for the swearing in of a young attorney. You're welcome to stay if you like.
All rise. The North Carolina Court of Appeals is adjourned.